So let's see how this works. You see that? My lawyer told me to put that in. All right, so immigration typically is a relatively strange animal to people who read about it and hear about it because they don't understand how it works. So in order for us to have a discussion about what's going on today, we need to understand how it works. And that's what we're going to do first. Then we're going to look at the more controversial activities that the current administration is engaged in and try and explain legally what's going on and practically what's going on. And then I'll give you my thoughts and duck. So the immigration laws generally relate to the entry and departure of people to the United States. I call them foreign nationals, people call them illegal aliens, but the illegality of it is not determined until they arrive. And so we're going to use the term foreign nationals because it's not pejorative, and I think it really describes what's going on. One court, I think deservedly so, compared these in complexity to King Minos's labyrinth in ancient Crete. They derive from the Constitution. The Constitution authorizes Congress to establish the law. And there are several provisions in the Constitution that give Congress the power to do this. I'm not going to belabor them, but it's important to understand that there are specific provisions in the Constitution that allow Congress to act here. These are not implied rights. These are specifically activities that Congress is authorized constitutionally to engage in. And then, of course, the Constitution in Article 2 authorizes the president to enforce the laws that Congress passes. So when we deal judicially with immigration cases, we typically deal with a statute that the Constitution authorizes Congress to pass. And we deal with activities which the Constitution authorizes the the president to enforce. The complexity arises because the president and the executive have created a whole bunch of administrative agencies that are involved in this process. And I've listed them on the slide. The ones that you're going to hear the most about are DOJ, the Department of Justice, and then I think it was 2002, the government had the creative idea to create something called the Department of Homeland Security. And what they did is they took one totally dysfunctional agency, which was the Immigration and Naturalization Service, and divided it up into a whole bunch of other dysfunctional agencies. One is Immigration and Customs Enforcement, which is ICE. You all hear about that. We'll talk about ICE in a minute. Customs and Border Protection, and U.S. Citizenship and Immigration Services. And they each have different functions as far as the regulation and enforcement of immigration laws. Department of State gets involved, even the Department of Labor gets involved. And the complexity occurs because each agency has their own set of rules and regulations, and they don't always comport with what the other agencies are doing. So that is the labyrinth that people who dabble in immigration or who deal in immigration have to go through. The Supreme Court is the ultimate arbiter of this. But the court has consistently held that where immigration is concerned, that Congress has wide leeway and can discriminate in ways that would be unacceptable if we're dealing with domestic legislation. The example there is the Chinese exclusion cases, which the Supreme Court upheld. Congress passed a law saying Chinese could not come into work. You could not have a statute that barred a specific nationality, but in the immigration context, you are constantly making decisions based on nationality. Can people from the UK come in? Can people from France come in? Are there different rules that apply to them? And the basis that they do that for is as an incident of national sovereignty. Countries have the right to determine who comes in and from where. And it's also incident to our foreign policy. So Congress can make these distinctions, which in a domestic context would be impossible. There are broad constitutional limits for Congress, but the court generally will allow the statutes to survive constitutional muster unless they clearly violate some other constitutional principle. And as far as the enforcement goes, the executive can enforce as long as there's a facially legitimate basis for what the executive is doing. And so what you're hearing a lot of these days is people saying, well, the court has sort of abandoned what's going up there in terms of immigration cases. But historically, the court really has never taken much of an interest in these cases other than to say, listen, Congress passed it, the executive's enforcing it. As long as it's consistent with the definition of the statute, we're really not going to get involved. Now, the basic law that governs all of this is the Immigration and Nationality Act, which was passed in 1952. So we're dealing with a statute that really is obsolete by anybody's definition. What it did is it created several categories of people. The first ones are immigrants. Those are people who have green cards, lawful permanent residents. There are a bunch of, they're permitted to stay and remain here and work indefinitely. They have an intention to be here, but they can be removed if they engage in certain illegal activities. Then we have non-immigrants, which is almost everybody else. It's a clever congressional ploy there. And they have an intent ultimately to go home. And there are 22 different categories and 80 different subdivisions. They all have letters. When you go to meet your cousin from Europe at the airport, they're coming in, if they're a tourist, as a B2. Because Section B, Subdivision 2, allows tourists to come into the United States and to stay for certain periods of time. Generally, they're admitted for a specific purpose, for a specific duration, and then they're supposed to leave. And there are quotas on most green card preferences and quotas on some non-immigrant preferences. So it's not like the world is wide open. And those preferences constitute political judgments as to what is in the best interests of the United States. If we are saying that a multinational manager is a preferred category because we want to engage in international commerce, then that person will be admitted before someone else. In most of the cases, they have to pass a labor test, a labor market test. You have to advertise to replace the person to show that you can't. So it's not like it's open season. But those political preferences largely date back to 1952. And things have changed a lot. And so we have a huge dissonance between what this statute allows and what the current economy demands. And that friction is really driving a lot of the debate these days. There are some other categories which we'll discuss. Refugees, asylees, temporary protected status is where something's going on in the country and they can't go back. And then DACA, which is for people who arrived here as children. No other country, but there's no immigration classification for them. So they've been permitted to remain by executive order. And unfortunately, a lot of those executive orders are expiring. Everybody agrees that something ought to be done, but nobody wants to touch immigration because it's a third rail politically. Once somebody wants to come here, they've got to go through what are called admissibility criteria. And there are 10 main categories, but basically we have a crook. Do we have someone with a loathsome mental disease? Do we have are they a communist? This is a 1952 statute. We're very concerned about communists. And they act as a filter. And so the Department of State, which issues visas abroad, is not supposed to issue a visa to anyone who doesn't satisfy the filter. It's a two-step process. The Department of State issues a visa. When the individual arrives at the airport, CBP, which is Customs Border Protection, those are those people you see at the airport. They run the passport through and they do an initial screening to see if they do a subsequent screening to see if there's anything about that individual that is flagged in any of the databases that are connected. And if there are, they'll throw them into what's called secondary inspection because they don't want to hold up the line. And if there's a problem, they'll arrest them, they'll detain them. The rights of an individual coming to the United States are at their most limited when they arrive in the United States. So when we're talking about the regulation of foreign nationals, we have, if they're here, they file applications, they file them to USCIS. Enforcement is handled by ICE. That's removal and deportation. And then remember that for the most part, removal is a civil proceeding. It is not a criminal proceeding. It is not illegal in a criminal sense to overstay your visa and stay here. And that's an important thing to remember as we go through this. So let's get to the controversial topics. I think the one that's on everybody's mind for the past several months has been this mass arrest program. And so let's take a look at that. Foreign nationals, once they get into the United States, are covered by the Constitution. And the Fourth Amendment prohibits an unreasonable search and seizure. It prohibits warrantless arrests without reasonable suspicion that people are here in violation of law. On the other hand, there's a statute, the INA, and immigration has broad discretion, and Section 287 permits ICE agents to conduct stops, namely interrogate any alien or person believed to be an alien as to his right to be or remain in the country. So we have a friction. We have a constitutional provision that says you can't stop anyone, you can't arrest anyone, you can't detain anyone. We have a statute that says you can stop them and ask them questions. And to satisfy the Fourth Amendment, the ICE regulations prohibit officers from detaining any person without a reasonable suspicion. So therefore, I mean, we're on pretty solid ground. I was in government. I was in the U.S. Attorney's Office here in New York. And it is not that easy to develop a case necessary to arrest someone or to develop the reasonable suspicion necessary to detain them. That's the way immigration and ICE had to operate since I've known them. In June of last year, the White House decided that they needed 3,000 arrests a day because they had been elected to stop illegal immigration. And so what ICE did to implement that executive directive was to order broad sweeps. And the sweeps were based on, the people that were targeted were based only on 4 factors: ethnicity, language, location, and the type of work. So if you looked foreign and you were in a place where foreign people congregated and you spoke a language other than English and it looked like you were going to work at a car wash, you were subject to arrest. The first sweeps were in Los Angeles, and there were over 1,500 arrests, and these led to lawsuits challenging these arrests based only on this 4-factor profile. The district court conducted a brief, expedited hearing and found that the sweeps were not stops, but rather they were arrests. And the factors that led to that largely were you had a pack of ICE agents, heavily armed, mass, surrounding someone. And the district court said, well, that doesn't smell like, look like, or feel like a stop. That is a detention, and therefore that violates the Constitution. And so the district court temporarily enjoined ICE from making further profile arrests based only on those factors. The Supreme Court temporarily reversed what the district court did. And they did it on something called their emergency docket. This is a docket where There's no briefing, there's no oral argument, there's very little record evidence that's submitted to the court. They just sort of make a decision on whatever the lower court put together. And the problem is, since there's no decision, nobody really knows why the court decided the way it did. And there's no guidance to lower courts as to how to operate. But in this particular case, Justice Kavanaugh issued a concurrence and published it. And Justice Sotomayor issued a dissent in which she was joined by some of the others. And basically what Kavanaugh was saying was, look, we've looked at this and we think that only stops are occurring. And we are extremely reluctant to enjoin a federal agency from carrying out an enforcement activity that the Constitution specifically authorizes. And Sotomayor took a look at the same record and the same facts and went a little bit broader and said, look, if you look at the geography of Los Angeles and the people who live there, a high percentage don't speak English, a high percentage are engaged in other activities. So these four factors are much too broad to justify or constitute reasonable suspicion. And for that reason, she found that the district court's decision was okay. Now, the emergency order, as I indicate, I think suggests that the court is more concerned about the executive's enforcement authority and curtailing that than it is about the individual civil liberties of the people who might be subject to that. And there is a problem with that because if you think about it, the standard that the district court set may have been a very difficult one for these agents to follow. You know, reasonable suspicion is not something you can sort of package and run off an assembly line. And if they can't use those factors as the sole basis, what are they going to do? And what I think the Supreme Court was concerned about was a series of contempt actions or subsequent lawsuits against the agents for acting in their official capacity. And so they said, listen, this is not enough of a record. We have to do a balancing act. And this is why we're deciding the way we are. So we leave Los Angeles and we move to Minnesota. And Minnesota has a rich history of inviting foreign nationals to live there. It was settled by Native Americans 6,000 years before Christ. It had open doors because it had open land and there was industrial development. There were refugees from over 13,000 from 30 different countries. And today, the foreign-born population in Minnesota is about 6.3% compared to the national average of 15%. And the foreign-born population in Minneapolis-St. Paul is 11%. Miami is 41%, and Dallas is 18%. So why Minneapolis, other than the fact that it was in Minnesota, which is a Democratic state? Well, the justification that the administration used was that there was massive Medicare fraud going on. And the largest case that they had instituted, the Department of Justice had filed, involved 92 defendants, or 93 defendants, and 82 of them were Somali Americans. So using that as the fulcrum, the administration decided it needed to do another massive immigration sweep to clear up this immigration fraud and this Medicare fraud. Now, it didn't have to worry about the reasonable suspicion because the Supreme Court had already upheld what they were doing in Los Angeles. And so they were free to do that. Now, they also exercised an extensive reliance on these administrative arrest warrants. The immigration laws do allow the Attorney General to issue an administrative means issued by an agency, not by a court. And so the Attorney General can just sign off, and it depends on the Attorney General as to what standards are used to issue those. But there is a reason that courts are generally required to issue search warrants, because you have an impartial arbiter as opposed to a political official. ICE claimed that these administrative warrants allowed them to follow foreign nationals that they suspected of being here illegally or had reasonable suspicion under their limited definition into private homes and businesses. And that's what created the explosion in Minnesota. Everyone they arrested was subject to mandatory detention. This was another new wrinkle that the administration added for Minnesota. There is a section of the immigration laws that says that where you're seeking admission and you can't establish that you are admissible, namely you can't satisfy the 10 criteria, or you're not in a proper visa classification or something else, and you're at the border, that you can be detained until your right to enter the United States is determined. And that makes some sense, because when you talk about due process is a scale, and it says, what is the liberty interest involved? What are the connections that someone has to this country? And what kind of process are they allowed to allow them to defend that interest? And where somebody's just arrived, they really have no connection. So the statute makes a great deal of sense. What the administration did is it adopted and going back, every administration since 1952 has followed INA section 236, which says that if somebody is here and they're arrested and suspected of being here illegally, that they are entitled to a bond hearing. So you can't release them if they're dangerous, but if they're not dangerous, you can release them. And the administration made the argument that everybody here illegally at some point is seeking admission, so they fall under 235. And they rounded up thousands of people. The case went to the Eighth Circuit, and there are two circuits, the Fifth Circuit and the Eighth Circuit. Unfortunately, the Eighth Circuit is the one that governs Minnesota. And they upheld this interpretation of the statute in a 2-1 decision. Both the Fifth Circuit and the Eighth Circuit were 2-1 decisions. The Second Circuit and the 11th Circuit, Second Circuit is where we are, have rejected it. And the Seventh Circuit split 1-1-1. They couldn't make up their mind. It is going up to the Supreme Court, and they will make the final decision. But if you think about it, the notion that Congress would have mandated mandatory detention for people who are already in the United States, may have lived here for 20 years. And all of a sudden they're picked up, suspected of being here illegally, they are detained. You need to build facilities to detain them. You've got to get through the court process to detain them. There probably would have been something else in the statute or something else in the budget would have supported this. But the administration felt that its primary responsibility was to make the world safe for democracy, and that's what they did. So what were the consequences of this? Mass arrests. Excuse me. It included U.S. citizens and permanent residents, because as long as they fit that broad profile, they would be swept up in this, and it may take weeks or months to get them out of detention. What the ICE people did is, as soon as they arrested them, they didn't have the capacity in Minnesota to keep them, so they shipped them down south. And as soon as the Fifth Circuit issued its decision, they kept shipping them down south, because the Fifth Circuit is the one that covers those southern states. As a result of this, there were several claims of misuse of force and civil unrest. There were 2 Americans that were killed, as you know, and there were multiple shootings and violent confrontations. When the Department of Justice did nothing about this, the state of Minnesota conducted its own investigation and has arrested an ICE agent and charged them with assault. I think there's a serious problem with that type of prosecution because I don't think individual states can apply their law to the activities of a federal agent who reasonably believes they're engaged in activities that are permissible. We'll have to see how that one comes out, but it really focuses attention back on the Department of Justice and what it's doing and what it's not doing with respect to these activities. The there were individual lawsuits by some of the people who were roughed up by the ICE agents, and I think they're going to run into the same problem. And it actually, these actions actually created a tremendous hindrance to federal law enforcement. In order to conduct these sweeps, they had to get the agents from somewhere. And they diverted 3,000 agents from drug trafficking and gun enforcement to go round up housekeepers in Minneapolis. When the Department of Justice asked the U.S. attorneys, assistant U.S. attorneys, to investigate the families of the people who were killed, 50% of them resigned. And you were left with a situation where, because of the volume of immigration litigation that was created by this, and the drastic reduction in assistant U.S. attorneys, they couldn't get to the criminal cases, much less the Medicare fraud cases that were supposedly the justification for this whole sweep in the first place. It also, I don't know if you read, there was some friction between Kavanaugh and Sotomayor, which dates back to that emergency docket orders that they both, one concurred and the other dissented, because Sotomayor was saying, I told you so. And Kavanaugh was saying, you missed the point. Now they've papered that up a little bit, but things are not always as calm and pleasant in the Supreme Court as a result of these immigration cases. This had a tremendous impact on Minneapolis. People were afraid to go out. When you have people who don't go to school, as in Scarsdale, you don't go to school, you don't get your state aid, budgets were affected. When people don't go to their doctors, public health is affected. There's one car dealer who was complaining, I think 75% of his business dropped because nobody was out on the street. The businesses in the local communities shuttered. So it was a major, major problem. And it created, listen, I was in the U.S. Attorney's Office. I was responsible in many respects for enforcing immigration laws, but doing it responsibly. It pains me that public respect for law enforcement is dropping because of these activities. Now, what did the administration do in response to this? Well, the polling numbers weren't great. People didn't appear to be supporting these great sweeps. And most of the people, I think there was 7% of the people they picked up in both sweeps had a criminal background. So what you're doing, you know, when you're looking to find criminal activity, it's like finding a needle in a haystack. If you build the haystack too big, you're never going to find the needle. And that's what was happening here. So they created and expanded this concept of self-deportation. It's make life so difficult for foreign nationals in the United States that they voluntarily decide to leave. So what are some of the elements of things that we're seeing? One, it blocked mixed status families from public housing. What does that mean? That means if you have a couple, one of whom may be undocumented, the other whom could be a U.S. citizen. They could have 13 U.S. citizen kids. They're gone. They're not entitled to public housing. Asylum seekers have a problem sometimes getting employed. They work as cab drivers, they work as truck drivers. Can't do that anymore. There's now a proposal pending to bar them from working at all. Now, there are approximately 2.3 million asylum seekers in the United States. And that number creeps up every year because the backlogs get worse and worse. The impact economically on putting those people out of work and the destabilizing aspects of doing that is significant. It's significant to them. It's also significant to the economies, to the communities where they work. And it's not going to get better because of this. The delays in immigration proceeding, the backlog in 2020 was in 1.3 million cases. And the delay was about 2 years. Now the delay is about 4.5 years, and we're talking about 3.8 million cases. So it gets worse and it gets worse. The immigration courts are overwhelmed, but the Department of Justice has also, and the Trump administration has also done something with them, and that is to try and get their impartiality out of the court system. So what they have done is they have fired immigration judges, any who have a defense, any relation to an immigration defense team. And so the number of judges now is way down. And there is an appeal group, Board of Immigration Appeals. I have my notes. They fired over 100 judges. And there's 750 to begin with. So it's a tremendous number, and that's why the numbers keep going up. The Board of Immigration Appeals hears appeals from immigration judges, and it has been reduced from 28 to 15. And also firing anybody with an immigration defense background. So when you talk about this concept of self-deportation, there are a number of different elements to it. And when you hear it in the news or you read it in the news, you don't understand how it connects. But it is all part of a consistent pattern of how you're going to get people to leave. And the explosion of these arrests simply exacerbates the problem because you have people caught in this system for much longer. The application of a mandatory detention system means that instead of spending 2 years, you're going to spend 4.5 years in one of these facilities. And you have people these days who want to leave. The Washington Post reported that there has been a 700% increase in the people with humanitarian claims wanting to leave the United States rather than pursue those claims. A major contributing factor may be that to date there have been over 45 deaths in those facilities. And NBC News reported that the deaths in the facilities had skyrocketed and was attributable to a systematic weakness in medical care at DHS immigration facilities. Why? Because the facilities never were meant to hold people for that long. And we are talking about civil confinement. This is, you didn't pay your traffic ticket. I mean, it's a little more serious, but we're not talking about criminal activity with a defined sentence where there's going to be a release date. It has created a climate of fear that has forced people underground. They also, in violation of federal law, have been reporting foreign nationals who file tax returns, getting that information from the IRS. So what has that done? People are not filing tax returns. So, we have a budget deficit, and we presumably would want people to file their tax returns. We're not doing that. Just a couple of the arrests. 22-year-old newlywed wife of a U.S. Army sergeant who was training to be deployed. An 86-year-old French woman who entered to marry her childhood sweetheart. And a single mother from India who was on her way to work and had worked here legally for a decade and had papers to show it, and it took her 40 days to get out. This is not the kind of stuff that I think any of us signed up to be. There's also a travel ban, and what the administration has done is they put a freeze on cases from people from 39 different countries. You can guess which countries they are. And they didn't realize when they did this that many of the doctors in rural communities are foreign nationals. And what they were doing was aggravating an already difficult situation in terms of healthcare providers in those areas. So this came out in January of 26. There was no publicity about it, but on May 3rd, the government eliminated the restriction on foreign medical graduates. And so now they are free to do this. On April 30th, a federal judge in Massachusetts found that this bar for these 39 countries was discriminatory and unlawful. I'm not really optimistic about the chances for that case on appeal. And the reason I went through the first part of this presentation was because courts, the administration, they're responsible for handling foreign policy matters, and courts really don't get into it. And so I think that one stands a difficult chance on appeal. So, this idea of self-deportation, many of the people they're trying to get rid of have never lived anywhere else or have lived here for so long. It's just not a viable theory. It creates an environment that is dangerous to the people who are here legally. Because when you drive people underground, especially with medical issues, you're not going to have them pay taxes, all the rest of that. You're just simply aggravating a difficult situation to begin with. And these people make significant contributions. So it's very difficult to extract them and not have consequences. And it's costly to maintain these kinds of programs. Maybe the money could be better served going to pay healthcare premiums. Maybe it could be better served doing other kinds of things. From my perspective, it's better served taking enforcement activities and prosecutions from serious criminals as opposed to some of this stuff. So that, I think, takes care, hopefully, you understand a little bit about what's going on in these mass arrests and sweeps. You're going to hear this phrase TPS. It's not a new television station. It's a section of the law that allows people to stay here if they can't go home. And once that designation is made, the foreign nationals can live here, they can work here, and they are here. They're not here legally in the sense that they haven't satisfied one of the categories. They are here as a matter of administrative grace because this statute says you are permitted to allow them to remain until the situation in their home country gets better. So the statute requires the Attorney General to review this within 60 days of the expiration of a TPS designation. That can be from 6 months to 18 months. And the statute precludes judicial review. So that means whatever decision they make, the substance of that decision is not subject to a court. These are just some statistics on the TPS program in the United States. The problem has been that the administration has acted so preemptorily in removing some of this that lawsuits have been successful. And they've been successful not challenging the substance, should you have done it or should you not have done it. They're saying procedurally the statute requires you to consult and you didn't. The lower court decision that involved Haiti and Syria, the consultation consisted of a single email from Homeland Security Secretary after the decision to terminate was made and after the lawsuit was filed, and a 1 or 2 sentence response. So after everything had taken place, they wanted to fix it. And the district court found that the Congress did not vest the DHS secretary with, and I quote, Humpty Dumpty-like power to make the word consultation mean just what she chooses it to mean. That case is up in the Supreme Court. And they agreed to decide 2 issues. One, do they have jurisdiction? Because there is that provision that says there's no judicial review. So they've got to figure out whether something like this means something. And if they do, what authority do they have to fix it? Now, the administration very easily could have done, well, we made a mistake, we'll do it over, but they don't do it that way. And I think the reason they don't is because they think they're going to have much better success and expand their authority in the Supreme Court by pursuing these cases. But the court also issued a stay, which meant that the termination was ineffective while the case was proceeding in the Supreme Court. And I found that very unusual because normally they just don't get involved. They didn't issue a stay in what was going on in Los Angeles. They just let it happen. So, I mean, it remains to be seen, but there may be a line in the sand that's too much for them. So the other thing you're going to hear about or you've heard about is birthright citizenship. The 14th Amendment grants birthright citizenship to all persons born or naturalized in the United States and subject to the jurisdiction thereof. And it was one of the old Civil War amendments because when the South lost the Civil War, there were all these blacks and other slaves who suddenly were there. And the question, they'd been born here, they'd been raised here, what was their status? And under the 14th Amendment, they were citizens because they were subject to the jurisdiction of the country. The reason you needed it was there was a Dred Scott decision that said they were not citizens. That was the Supreme Court way back in 1857. So you needed something to fix that. The Supreme Court has construed this provision before, not a lot, to mean that children born here of immigrant parents are American citizens. And this has gone on for decades. But this administration chose to challenge the reading as part of, I think, an overall attack on immigration. It fed the narrative that they were going to be tough on illegal immigration. The DOJ also challenged the original cases. The district courts issued nationwide injunctions. And the courts generally had been doing that. Neither political party was terribly happy with it. When the Republicans didn't like what the Democrats were doing, they would go to this district in Texas, where there's one judge who always agreed with them. And when the Democrats didn't like what the Republicans were doing, they'd go to a district court in San Francisco. So it was a big game. And the first appeal to the Supreme Court did not touch the birthright citizenship issue, but instead invalidated the injunction. So the plaintiffs went back to New Hampshire. They satisfied the procedural rules for getting it, and they did it again. And the court issued an opinion. It's now back up on the Supreme Court. It was argued on April 1st. Hopefully they're not playing a joke on anybody, but Um, there are severe consequences to an adverse decision here. I don't think the court is going to do that. Um, but you've got at base about 2.5 million people who were born here, who were raised here, and who think that they have every right to stay here, who suddenly might be in jeopardy. And that has a ripple effect through communities, through families, through the economy. Um, whoops. There was um, somebody did some research, suggested that the US economy would lose over 7 billion immediately if this turns out the other way. So there is a big issue here, and I think that the court is going to handle it the right way. But it's part of a pattern, and I think it's a strategy to restrict access to U.S. citizenship or to strip it from those who have it. So what you're seeing is administratively, most naturalization applications go to USCIS. They handle applications in the United States. You've seen an extraordinary number of delays in application processing, in the administration of oaths, the conduct of interviews. Everything is slowing down. And they're using far more subjective standards to address this, so that if a case is denied, there's an appeal to the district court, but that takes a long time and it's costly, and you don't know what kind of resources people have. They have also begun to use denaturalization as a top enforcement priority. When I was in the U.S. Attorney's Office, we handled a couple denaturalization cases. They were of Nazi war criminals who entered under the Displaced Persons Act and lied, got U.S. citizenship, and we sought to remove that. And that was the kind of case where denaturalization was sought. I was reading today that the Washington Post reported they filed 12 new cases today. So the question is there an election coming? Who votes in election? What are these? I mean, is this the immigration version of the SAVE Act? What are they doing? So, you know, look at immigration law is a difficult area to be, because you have to decide difficult policy questions, and you're dealing with human beings, and I fully recognize that. I was on the enforcement side. When I was in the U.S. Attorney's Office, Castro cleared out his jails and sent all those people to the United States. And we had to deal with that. So believe me when I say that I am very strongly in favor of enforcement, but enforcement done fairly and enforcement done intelligently, and enforcement that leads to an efficient use of resources. And foreign nationals are here. They provide a critical source of ingenuity to us. They provide a critical source of labor. The difficult question, and we're dealing with a statute from 1952, is what should this look like? And all of this enforcement activity really has created a very unfortunate smokescreen, in my view, because the focus should be on the statute. What level of immigration, what types of immigration would be in the national interest today? And we are not talking about that. We're talking about arrest warrants. We're talking about habeas corpus petitions. We're talking about detention. That just simply doesn't fly with me. The opportunities costs of this are significant. You know, the administration said they want to get rid of the worst of the worst. Well, because of their activities, they can't find the worst of the worst, because they're going nowhere near any of these sweeps that the people are doing. You're arresting people at courthouses. Who is going to attend their immigration hearing? It's somebody who thinks that they have a chance to stay here and that an immigration judge will decide it for them. Why are we pursuing it this way? The executive order created a mobilization and a top priority for law enforcement agencies and offices on immigration. So you have National Guard mobilized. You read about that. You have ATF agents taken off investigations and sent to do sweeps. ProPublica reports that the DOJ had to drop over 23,000 criminal investigations to focus on immigration violations. And the federal prosecutors in Minneapolis, as I mentioned, were so inundated with all these immigration cases that they can't investigate the Medicaid fraud, which was the predicate for sending people in there in the first place. And now denaturalization is another top priority over rapists, muggers, and whatever else. Mandatory detention also has an enormous impact, ripple effect on the courts. In the tri-state area, this is where I could find statistics. In 2021, 2024, there were 41 habeas cases filed. These are actions where an individual says, I'm being wrongly detained and wants a federal judge to decide it. That's what a habeas corpus case is. It predates the Constitution. In the first 3 months of 2026, there were 1,686 of these cases filed. Each one of them needs to be defended by an assistant U.S. attorney who presumably has other things to do. I know I did. Nationally, during the first 13 months of the Trump administration, there were more habeas corpus petitions filed than during the entire 3 previous administrations. That's what we're spending our time doing. The question is this the most effective and efficient utilization of federal resources? And I suggest to you that it's not. So the bottom line to me is that this enforcement is actually undermining our ability to get rid of the worst of the worst. It's undermining our ability to create a justice system that is fair and equal for all. And the reason I'm doing this is because I can't prosecute anymore. I wouldn't go near the Department of Justice today. But I think it's important for voters to understand what they're reading, because you read about something, immigration judges are fired, or you read about the BIA, or you read about the arrests in Los Angeles, or what's going on in Minneapolis. And it's very difficult to frame all of this as part of a consistent pattern. And this is a political pattern. This is an administration that felt that it was elected to solve what it perceived of as an immigration problem. And that's what this focus has been. And it will take political resolve to address that. Thank you.